whenever he wishes, a la King George. If we accept that view, then not even common sense or an English dictionary or the Constitution, which we swear to uphold, can act as a constraint. As to the underlying laws that give the President emergency authorities, a lot of scholars and commentators have pointed out that we in Congress have almost lost track of how many authorities we've granted to the President, or whether these grants of emergency authorities remain warranted. Ms. You're on. Goitin will describe some of those laws for us, many of which have never been used. Nonetheless, they remain on the books, and as Justice Robert Jackson put it in a famous dissent on a different emergency claim, they, quote, lie about a loaded weapon. Lie about like a loaded weapon, unquote. Tellingly, after President Trump began talking in late 2018 about declaring a national emergency, a lot of lawyers and scholars spent weeks spinning their wheels trying to figure out which laws he was talking about. The President's own budget director told the press about how he and his staff combed through the U.S. Code looking for hidden emergency authorities or other loopholes that allow them to move money around. The American people deserve better than that. They deserve to know the President cannot rewrite the law or exploit obscure loopholes to raid funds that have been allocated by Congress for different purposes. And particularly when Congress has acted at the President's request, the President was going to accept what Congress gave him and then said no after he heard from talk show radio host. Then he shut down the government after Congress wouldn't give him his funds, and then after 3 weeks, Congress voted together in a bipartisan fashion to give him what funds they thought were appropriate, and then he declared a national emergency. He basically declared Congress null and void. So I look forward today to hearing from all of our witnesses who bring a range of perspectives about these issues. I hope we have a productive and fruitful discussion, not only about President Trump's actions, but about whether we as Congress need to do more to constrain these type of authorities and amend this law so they're used only in true emergencies and not as an end run around our Constitution. I now recognize the distinguished ranking member, Mr. Johnson, from the Go Tigers state, for his opening statement.
Thank you, Mr. Chairman. I appreciate you and all of our colleagues and look forward to working with you all on the subcommittee this year. And thank you to our witnesses for being here with us. Today's hearing on the National Emergencies Act of 1976 takes place at a time in history in which Congress has increasingly abdicated its legislative powers over many decades. It's like having a hearing on puddles right now in the middle of a hurricane. That's my Louisiana reference for you. I'd like to use my time today to take a step back and explore how the polarization of Congress seems to have drawn both parties at times further away from our constitutional core, and namely, that is what's been referenced, Article 1 of the Constitution. As the former historian of the House of Representatives, Robert Remini, has written, quote, "The framers of the Constitution were absolutely committed to the belief that a representative body accountable to its constituents was the surest means of protecting liberty and individual rights. So anxious were they to affirm legislative supremacy in the new government that they failed to flesh out the executive and judicial departments in the Constitution, leaving that task to Congress and thereby assuring that the legislative and the legislature would remain control of the structure and authority of both of those branches," unquote. But today, the separation of powers, so carefully designed by the framers of our Constitution, has been greatly obscured. Let's take a look at more recent history. Just consider the last 5 years. The first section of the first article of the Constitution provides that, quote, "all legislative powers herein granted shall be vested in a Congress of the United States," unquote. And in the Obamacare statute, Congress provided for clear statutory guidelines for compliance, including this one regarding the mandates the statute imposes on employers. Quote, "The amendments made by this section shall apply to months beginning after December 31, 2013. Yet the Obama administration unilaterally sought to rewrite the law, not by working with the people's duly elected representatives, but through things like blog posts, where they removed penalties for employers who would otherwise be required to provide insurance coverage for their employees. They did it through regulatory fact sheets, which created an entirely new category of businesses and exempted them from their responsibility under the law. They used things like letters, which specifically explained that people would have to have their health insurance terminated under Obamacare, of course in violation of President Obama's famous promise that if you like your health care plan, you can keep it. And then they claimed to suspend the law's insurance requirements to a date uncertain. This one letter alone, referenced there, suspended the application of 8 key provisions of the Obamacare law. And why was this done? To delay the terrible consequences of Obamacare until after the next election cycle. The Obama administration also admitted to using federal taxpayer money to pay subsidies to insurance companies under Section 1402 of the Affordable Care Act, even though appropriations for such payments were never made by Congress, in violation of Article 1, Section 9, Clause 7 of the Constitution, which expressly states, quote, "No money shall be drawn from the Treasury, but in consequence of appropriations made by law," unquote. When it submitted its fiscal year 2014 budget to Congress, the Obama administration correctly recognized it could not make Section 1402 offset program payments to insurers unless and until Congress specifically appropriated funds for that purpose. In July 2013, the Senate Appropriations Committee declined to approve the administration's request. In fact, neither the House nor the Senate ever adopted a bill approving the administration's request, and no bill containing an appropriation to fund that section was presented to the President for his signature or veto. Congress also didn't appropriate funds for Section 1402 for fiscal year 2015, and yet the administration went ahead and funded the insurance subsidy program anyway. Notwithstanding the lack of any appropriation for that section, either in Obamacare in that law or in any fiscal year 2014 appropriations bill, the Obama administration unilaterally began making such payments to insurers in January 2014 and continued making them thereafter. One of the witnesses here today, Professor Jonathan Turley, challenged the rank unconstitutionality of those unilateral executive actions on behalf of the House of Representatives, and it led to a federal district court ruling that said, quote, "Neither the President nor his officers can authorize appropriations. The assent of the House of Representatives is required before any public monies are spent. Congress's power of the purse is the ultimate check on the otherwise unbounded power of the executive. The genius of our framers was to limit the executive's power by a valid reservation of congressional control over funds in the Treasury. Disregard for that reservation works a grievous harm on the House, which is deprived of its rightful and necessary place under the Constitution." Judge Collier ultimately ruled in favor of the House on May 12, 2016, and found that the Obama administration violated the Constitution in committing billions of dollars from the U.S. Treasury without the approval of Congress. The Trump administration subsequently ended that unconstitutional funding program. Then November 2014, President Obama unilaterally and unconstitutionally created a program that would suspend immigration laws for millions of people who are in this country illegally without authorization by Congress. The President urged Congress to enact a statute to create such a program under law, but Congress did not, even when his party controlled both houses of Congress. And despite claiming the situation was urgent, he didn't act unilaterally until November 2014. Whether or not the President delayed action until November 2014 for political reasons, he knew the actions he ultimately did take were unconstitutional. And we know that from his many public statements in which he himself directly addressed the issue of the lack of legal and constitutional authority to do what he ultimately did, that he recognized it as well. He said in his own words at one point, he changed the law. Now, all that happened without any protest from the other side of the aisle, even though both sides of the aisle work together here under the same Capitol dome, and we share the same legislative powers under Article 1. But today, here we are having a hearing on President Trump's exercise of clearly delegated authority under a statute that was duly enacted by Congress. We can debate the policy merits of the authorizing statute, but there's no doubt the National Emergencies Act of 1976 and related federal statutes constitute a clear delegation by Congress of parts of its appropriation powers to the President, subject to the President's declaration of a national emergency, which is a term that is left to the President alone to define. There is a crisis at the border, and everyone at some point or another has acknowledged that, and the President has the authority to address that crisis under a federal statute that's duly enacted by Congress. I would just say this in closing: it's time to drop the politics and pick up our principles. We in Congress must rediscover the principled basis for our Article 1 powers. Until we do that, we will move in partisan fits and starts, one day in this direction, next day in that direction, and we'll discover one day that we're not moving forward, but rather in circles, down a whirlpool that erodes our legislative powers, spinning with increasing speed in smaller and smaller circles. I hope this hearing can help right our ship and help provide us a principled anchor as Congress moves ahead. I look forward to hearing from all of our witnesses here today. I yield back.
I thank the gentleman from Louisiana for his statement, and I now recognize the chairman of the full committee, the Honorable Gerald Nadler of New York.
Thank you, Mr. Chairman, and thank you for convening this hearing on this important topic. I would also like to thank all of you witnesses for appearing here today. I am heartened by the fact that their opposition to President Donald Trump's emergency declaration comes from across the political spectrum, because ultimately this debate should not be about partisan politics. It should be about protecting a principle that is fundamental to our constitutional democracy, namely that the chief executive cannot unilaterally spend taxpayers' money or redirect funds appropriated by the people's representatives. Article 1, Section 9 of the Constitution makes it unmistakably clear that, quote, "No money shall be drawn from the Treasury but in consequences of appropriations made by law," close quote. President Trump violated that basic command when he when he invented a so-called emergency as an excuse to build a wall that Congress explicitly rejected. The only emergency is the fact that Congress refused the president what he wanted. That kind of bad faith action by the president is a violation of his oath of office to defend the Constitution and to faithfully execute the law. In addition, the emergency law that President Trump invoked allows the military to redirect funds only if an emergency, quote, requires use of the armed forces, close quote. And those funds can be used only for construction projects that are, quote, necessary to support such use of the armed forces, close quote. This law is supposed to be used for actions such as building airfields or barracks to help our troops fight wars overseas. A wall, however, cannot possibly be, quote, necessary to support, unquote, a military operation on the border because the Posse Comitatus Act and related laws expressly prohibit the military from engaging in law enforcement activities. The military, therefore, cannot enforce our immigration laws or our drug smuggling laws. That means the president's actions are doubly unlawful. There is no real emergency, and even if there were one, the president could not redirect military funds for a purpose expressly prohibited by law to the military. This past Tuesday, the House passed a joint resolution to terminate this so-called emergency. That was an important first step in reasserting Congress' role as a check against President Trump's unlimited appetite for power. And I hope that my colleagues in the Senate, particularly those on the other side of the aisle, will take a hard look at the bigger principles at stake, including their own role in our constitutional system, when they go to cast their votes. And let me paraphrase, I think it was Senator Rubio. If today the so-called emergency is at the border, tomorrow the emergency could be climate change or guns. We actually have a gun emergency in this country. What would you say if the president declared an emergency and said we're going to collect all the guns in the country and melt them down the way they did in Australia? I would say that was unconstitutional. But the people who uphold this emergency use of this emergency power now would have to say, to be consistent, that that was a proper use of the president's emergency power. No president should have that kind of unlimited power. That is what is at stake here. But this hearing is about more than debating the legality or the merits of the president's February 15th emergency declaration. His decision to invoke the so-called emergency authority should give all of us great pause, because those authorities go beyond the ability to redirect funds in order to build a wall. The National Emergencies Act, which regulates the process by which the president can declare an emergency, was enacted by Congress in 1976 in order to curtail certain abuses of emergency authorities that had come before. The Act provides a general framework through which the president can declare national emergencies and through which Congress can review and terminate them. Importantly, at the time the law was enacted, it allowed Congress to terminate any emergency by a majority vote in both houses. But in 1983, the Supreme Court held that Congress cannot veto actions taken by the executive branch through majority votes in the House and Senate. Instead, if Congress wants to override the president's actions, it has to pass a new law, which means it has to get the president's signature or pass the law with veto-proof majorities. Consequently, in 1985, Congress amended the National Emergencies Act to be consistent with that ruling. Unfortunately, in doing so, Congress abdicated a substantial amount of its constitutional power to constrain the president. The bottom line now is that if the president declares an emergency and we in Congress do not like it, we either have to convince the president to sign a joint resolution to terminate his own emergency declaration, an unlikely occurrence, or we need a veto-proof majority, which is very difficult to muster. As to President Trump's bogus emergency, I think on principle that every member of the House and Senate should vote to terminate it. The administration can scarcely tell you with a straight face that there is an emergency on the southern border. Take the partisan politics away, and this would not be a close call. But whether we are addressing this so-called emergency or some future emergency declared by some other president, it should not take a supermajority of Congress to stop the president from abusing power that has been delegated to address urgent circumstances. As Elizabeth Goetin will describe, there are numerous emergency statutes that give the president a broad range of potential authorities, including the ability to bar certain exports or even potentially to take control of communications networks, all of which could be subject to abuse by a president who does not respect the rule of law. We may agree that the president should be allowed some types of discretion during true emergencies, but an emergency cannot continue forever. So to shift the burden of inertia, we should consider legislation that would set a time limit for emergencies, requiring that they automatically expire after a short period, say 10 days, unless Congress ratifies the emergency declaration by law. This type of sunset provision, and I emphasize it should be in the days, not the weeks, would restore the authority and the responsibility to change the law to where it belongs, in Congress. We should also consider separating out which so-called emergency statutes are designed for true emergencies and which ones use that term to describe other contingencies that may call for particular responses within the executive branch, which do not involve truly urgent circumstances. I recognize we will not solve all these issues today, but I am eager to begin this important dialogue. I thank the witnesses for their participation. I look forward to their testimony. I yield back the balance of my time.
Thank you, Mr. Nadler. I'm going to introduce the witnesses, but I like to introduce them individually before they speak, rather than as a group. So first, I think before we introduce Ms. Goitein, we're going to ask all of the witnesses to stand and be sworn, as has become a custom in our committees. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? Thank you. Let the record show the witnesses.
Point of parliamentary inquiry.
Yes, Mr. Johnson.
I think we left out the phrase, "so help me God."
We did.
Could we have the witnesses do it again for the record?
Yeah, if they want to do it, but some of them don't want to do it, and I don't think it's necessary, and I don't like to exert my will over other people.
Well, it goes back to our founding history. It's been part of our tradition for more than 2 centuries, and I don't know that we should abandon it now. Could I ask the witnesses if they would choose to use the phrase?
Mr. Chairman,
Mr. Nadler.
if any witness objects, he should not be asked to identify himself. We do not have religious tests for office or for anything else, and we should let it go with that.
We'll
Proceed and introduce the first witness.
Glad it's noted for the record.
Ms. Elizabeth Goitein is a co-director of the Brennan Center for Justice, Liberty, and National Security program. She is the author of numerous articles and reports regarding national security and civil liberties. She's also the author of an extensive piece in the January-February issue of The Atlantic titled "What the President Could Do If He Declares a State of Emergency." Before coming to the Brennan Center, Ms. Goitein served as counsel to Senator Russ Feingold, then the chairman of the Constitution Subcommittee of the Senate Judiciary Committee, and as a trial attorney in the Federal Programs Branch of the Civil Division of the Department of Justice. Ms. Goitein received her J.D. from Yale Law School and clerked for the Honorable Michael Daley Hawkins on the U.S. Court of Appeals for the Ninth Circuit. She received her B.A. in History from Yale and a Master's of Music degree in oboe performance from the Juilliard School. Welcome, and we would like to hear your testimony in your 5 minutes to give us.
Chairman Cohen, Ranking Member Johnson, and members of the committee, thank you for this opportunity to testify on behalf of the Brennan Center for Justice. President Trump's declaration of a national emergency to build a wall along the southern border is an unprecedented abuse of emergency powers. The president declared this emergency for the stated purpose of getting around Congress, which had repeatedly refused his requests for funding to build the wall. No other president has used emergency powers in that way. Emergency powers are not meant as an end run around Congress. They are simply standby authorities that Congress has passed in advance, recognizing that true crises often unfold too quickly for Congress to respond in the moment. They're akin to an advanced medical directive, where a person specifies what action a doctor can take in an extreme situation where the patient might not be able to make her wishes known. A president using emergency powers to thwart the will of Congress in a situation where Congress has had ample time to express that will is like a doctor relying on an advance directive to deny life-saving treatment to a patient who is conscious and clearly asking to be saved. Congress passed the National Emergencies Act in 1976 to try to prevent abuses of emergency powers. The law provided that states of emergency would expire after a year unless unless the president renewed them. It allowed Congress to terminate states of emergency without the president's signature, using a so-called legislative veto. And it required Congress to meet every 6 months while emergencies were in effect to consider a vote on whether to end them. The law has not proven to be the check that Congress intended. Expiration of emergencies after a year, which was supposed to be the default, has become the exception. Presidents routinely renew states of emergency for years on end. The Supreme Court in 1983 held that legislative vetoes were unconstitutional. So now it requires a joint resolution signed by the president or passed over the president's veto for Congress to terminate a state of emergency. And Congress has simply ignored the requirement to meet every 6 months to review existing emergencies. In addition, when Congress passed the act, it didn't include a definition of national emergencies. The legislative history makes clear that this omission was not intended to give the president unlimited discretion, but the fact remains that there are no clearly articulated standards in the law. Recognizing the unprecedented nature of this emergency declaration, the House has voted to terminate it. The Senate should do the same, and if the president vetoes the bill, Congress should override the veto. All of the witnesses here today agree on that point. The court should also play their constitutional role. While the National Emergencies Act gives the president tremendous discretion, even the broadest of discretion can be unlawfully abused. But these responses are not enough. We've now seen how the permissive legal scheme for national emergencies can be exploited. The next time, the stakes could be even higher. The Brennan Center has cataloged 123 statutory powers that are available to the president when he declares a state of emergency. These include some incredibly potent authorities, including the power to take over or shut down communications facilities, to freeze Americans' bank accounts, to detail members of the U.S. Armed Forces to any country. Congress should act now to pass common sense reforms that preserve the president's flexibility in a true crisis while better safeguarding against abuse. I made 6 recommendations in my written testimony, and I'll just flag the top 2 here. First, Congress should clarify that an emergency involves significant changes in factual circumstances that pose an imminent threat to public health, public safety, or other important national interests. This definition would leave the president with plenty of discretion, just not a blank check. Second, Congress should vote that an emergency should end after 30 days or 10 days if Congress doesn't vote to continue it. This, again, would give the president ready access to enhanced authorities when he needs them most. But when Congress has had time to act, and Congress can act very quickly in the face of real emergencies, at that point, it should be up to Congress to decide whether emergency powers should be used. In short, it's past time for Congress to reassert itself in its constitutional role as a co-equal branch of government. And again, that's something all the witnesses here agree on.
Thank you, Ms. Goitein. Now we have Ms. Naida Alvarez, who is a teacher, a mother, a grandmother, and a border landowner. Her family has lived along the border in Starr County, Texas for at least 5 generations. She has received letters from the U.S. government indicating its intention to take her property for construction of a border wall that would cross her backyard. There's a 5 minutes, and I think you've got green, your go, yellow, you're getting close to ending, and red, over. Thank you, Ms. Alvarez. We appreciate your attendance and testimony.
Good afternoon. Thank you, Chairman Cohen, Ranking Member Johnson, and members of the committee for inviting me here to share my story. My name is Naida Alvarez. I live in Starr County, Texas, in an area known as La Rosita. My backyard extends to the Rio Grande River, which forms the border between Texas and Mexico. I'm here today to testify that there is no emergency where I live, and there is no good reason for the government to take my property to build a wall in my backyard. My family has lived on land along the Rio Grande River in Starr County for at least 5 generations. I have lived on this land for more than 40 years. My father lives next to me, alongside the land where my grandfather lived. We still use a wooden corral built by my great-grandfather for keeping farm animals. My grandchildren and nieces and nephews play in the same places where their parents played and where I played as a child, along with my siblings and cousins. In more than 40 years of living on the border, I can't remember ever seeing migrants from Mexico come across my family's property. To do so, they would have to cross the river, and then they would have to climb up the soft bluff that runs alongside the river at the end of my property. The river and the bluff create a natural barrier on my family's property, a natural barrier between Mexico and my land in the U.S. Because my property and my family's property next door is not an area where migrants cross the border, we were surprised in September 2018. We received letters from Customs and Border Protection asking for permission to come onto our land to survey and take soil samples in anticipation of building a border wall across our property. We did not grant permission. In November 2018, another letter was hand-delivered to us. In January 2019, we received a third round of letters stating the United States government is going to take us to court to take our property to build a border wall across our land. The government sent maps that show a wall and a maintenance road to be constructed feet from the back of my house. This described a 150-foot wide enforcement zone between my house and the river. But the river is only about 200 feet from my house, and the land closest to the river is unstable and subject to erosion. How will my house survive? In January, using a telephone number provided in the January letter, I called a U.S. Army Corps of Engineers realty specialist to ask how they would possibly fit the border wall and enforcement zone between my house and the river. The person I spoke to told me that they were going to build the wall if they got money in 2019, even if they had to squeeze it in there. Even if my house is spared, it will never be the same. I will lose my entire backyard, and I will be staring at a wall right outside my back door and windows. My family's property next door, where we enjoy family gatherings, raise animals, and enjoy nature, will be divided by the wall, with about 2/3 of the land on the south side of the wall. Because Congress would not appropriate the funds to build a border wall, the president declared a national emergency to try to build a wall anyway. The president's end run around Congress is unlawful. As my lawyers at Public Citizen have explained in a lawsuit filed against the president on the same day he issued his emergency declaration. While my lawyers will argue the legalities of the president's action, the bottom line for me is that the federal government is threatening to take my land to fulfill a campaign promise, but without any need. I can tell you that there is no invasion in Stark County, no emergency, no need for a wall across the land. I live on a peaceful stretch of property along the river in South Texas, in the United States of America. No drugs, no gangs, no terrorists come across my property. There is no need for a wall on our land. My family should not have to sacrifice our ancestral home to a campaign slogan. We're going to lose our land, our privacy, and our way of life. Thank you again for granting me this opportunity to testify. I am ready to address any questions you may have.
Thank you, Ms. Alvarez. We appreciate your attendance and your testimony. Mr. Jonathan Turley, another individual with a Louisiana background, although he's a greenie, not a Go Tiger, is a J.B. and Maurice C. Shapiro, professor of public interest law, and the George Washington University School of Law. Nationally recognized legal scholar, has written extensively in areas ranging from constitutional law to legal theory to tort law. In addition to being the author of over 36 academic articles, he served as a counsel in many notable cases. Among those was his representation of the House in 2014 and his constitutional challenge to certain implementation decisions made by the Obama administration with respect to the Affordable Care Act. He's also a star of stage, screen, and television, at least the latter. Professor Turley received his BA from the University of Chicago and his JD from Northwestern. In 2008, he was given an honorary doctorate of law from John Marshall Law School for his contribution to civil liberties and the public interest. We appreciate your attendance and welcome your testimony.
Thank you, Chairman Cohen, Ranking Member Johnson, Chairman Nadler, and the members of the subcommittee. It's an honor to appear before you today to talk about this very important issue involving the National Emergencies Act of 1976. As some of you know from my background, I am an unabashed and unapologetic Madisonian scholar, and for that reason, I tend to favor Congress in fights with the executive branch, and indeed, I often appear before members of this committee like a broken record, warning Congress that it is frittering away its authority to an expanding executive power. Like my testimony, most of the testimony of scholars along those lines have been ignored. The National Emergency Act is the archetype for this long acquiescence of this body. Originally portrayed as an effort to restrict presidential power, it ultimately was passed as an unfettered grant of authority to allow declarations to occur with little check of this body. This Congress has also tied that type of unfettered authority to a history of appropriations that often place few conditions on funds given to the executive branch. The result is the long and frankly irresponsible history that led us to this problem. Although I disagree on a policy level with the declaration in this case, it doesn't matter. This problem is the making of Congress, not the president. Courts are not designed to protect Congress from itself. The National Emergencies Act was a case of snatching defeat out of the jaws of victory. 20 years earlier, this body prevailed in the Youngstown Sheet and Tube Company. It was one of the most important rulings ever to come down for the legislative branch. In that opinion, Justice Jackson warned that the type of emergency powers being claimed by President Truman would be a pretext for authoritarian rule, and that emergency powers, quote, would tend to kindle emergencies. This Congress responded 20 years later by creating a law that allowed that very problem to occur. There's an old adage that the road to hell is paved with good intentions, and if that's true, this body stopped to pass the NEA on the way. It started by saying it wanted to restrict the president's power, but through a series of amendments that I go through in my testimony, what came out was basically an unfettered grant of authority. The result has not been surprising. We've had more than one national emergency declared every year since the NEA has passed. It would be funny if it was not tragic for this body and its inherent constitution. Even express provisions in the law, like this body meeting every 6 months to review emergency powers, simply ignored. This body hasn't done it once because it was too inconvenient, apparently, or burdensome. Now, if you sense a sense of frustration, then you are picking up the truth about how I view this problem. Congress created a law that gave unfettered authority. Congress can rescind that law. Congress can rescind emergency declarations. A court is unlikely to do it. There are two possible challenges to the current declaration by President Trump. One is the source of authority, and one is the source of the funds. The source of authority, which occupies much of the multi-state complaint, I'm afraid, is not a very promising attack on this problem. They are unlikely to prevail. I can put it no more bluntly than this. This is a national emergency because the president says it is, because you gave him that authority. That may seem superficial and simplistic, but the NEA is superficial and simplistic. I don't see how a court is going to substitute its authority as to what an emergency is when the law itself doesn't even define it. As for the source of the funds, there's a simple math that leads to a simple problem. This body gave the president roughly $1.4 billion. We can fight a debate as to how that can be used. The administration has identified multiple sources that would bring up the available funds to $8 billion. Even if a court was to enjoin two of those different sources of funding, it would still be over the $5 billion that the president originally sought. So it is unlikely, in the long term, that a challenge will stop this construction. Let me end by saying that Oliver Wendell Holmes once said that if my fellow citizens want to go to hell, I will gladly help them. It's my job. Well, this body has been hell-bent for a long time, and you are not going to be rescued from that direction by a federal court. It will send you along your path, a long chosen road towards institutional obsolescence. I hope that this hearing, instead of focusing on the lawsuit, which I think is not particularly promising, will look at correcting this law and regaining the authority that this body unwisely frittered away in 1976.
Thank you, Mr. Turley. I appreciate it, Professor Turley. Finally, we have Stuart Gerson, who's a member of the law firm of Epstein, Becker, and Green. His practice has centered on providing representation to clients in the health care industry particularly. He's had a long and distinguished career serving both as acting Attorney General and Assistant Attorney General for the Civil Division during the administration of President George H.W. Bush. He also serves as an advisor to several presidents, including serving on the transition team of President George W. Bush. He receives a J.D. from Georgetown University Law Center and his B.A. from Pennsylvania State, Penn State. He is not as commonly on television as Mr. Turley, but he started with the team of Tribe and Gerson as TV personalities. We welcome Mr. Gerson.
Thank you, Mr. Chairman. Chairman Nadler, pleasure to see you again. Mr. Chairman, Ranking Member Johnson, and I especially give a nod towards Ms. Escobar, whose home county is my client in the litigation that Professor Tribe and I are sharing, and which doesn't bear the characteristics criticized by Professor Turley. I'm a lifelong Republican. I've been a Republican longer than some of you have been alive. And I'm a conservative Republican, and I enjoy the support of a lot of conservatives with respect to the position that I'm taking today. Indeed, I'd take that very position if I agreed with President Trump with respect to his desire to build a contiguous border wall. I don't. I'm a tech wizard and know a lot about what DARPA has done since Vietnam in creating technical means, and I like those a lot better. But I don't favor open borders, and I don't know anybody here that does either. And so I'm here as an advocate for the Constitution. And in fact, I agree with 95% of everything that I've heard from everybody so far. And I expect that to continue. Mr. Johnson, Professor Turley, and I disagree as to one point, and that is with respect to the ability of a neutral, of a judge to determine an emergency. But in terms of the history, we don't disagree at all. And I was as much a critic of acting contrariwise to Congress by the executive in the previous administration as I am presently. As I say, even if I agreed with the president, I'd have the same position. Your job is to revisit the act, and I am hopeful and expect that you will do it, and in so doing that the Congress will stop acting like a parliamentary body and will act as what James Madison, Alexander Hamilton, and the other framers intended, which was an adversary to the executive branch. This goes back, even in my lifetime, to the 1940s, and it has been a continuous trend. And I say that as somebody who represented the first Bush administration arguing in court all the way up to the Supreme Court about the president's war powers. Different from what we have here, but certainly this entire case cries out for the definition of what constitutes an emergency, where a president can act, and for how long. Why I think a neutral will be able to decide this question, notwithstanding my full agreement with Professor Turley that the act is currently written looks like a turducken, if I can give you a Louisiana reference, things slapped on one another, eliminating old emergencies that persisted for years. But the reason why I think that a court will be able to do that is that I don't think you can be the referee of your own game. And I don't think that using just the textualist tools that I believe are proper when I support the judicial nominees of this administration, which I generally do, that emergency requires a definition. It's got to be an exigency of some kind, unplanned, sudden, that requires action in a time frame too short for the two political branches to confer and to act. That's similar to what other witnesses have had to say. One can argue about the language, but I think we know what an emergency looks like when we see it, if I can paraphrase Justice Stewart. And that's what I'm asking you to do. As far as the litigation goes and our ability to challenge the act, I'm comfortable with the positions that we're taking. It's a coalition of organizations, left, right, and center. None of us views it as political. It's simply that we believe that it's constitutionally impermissible for the president to take action in what really is a non-emergency when the Congress has already spoken and told him not to do the very thing that he's doing. In a sport, the Constitution intended that there be winners and losers, and something ends a particular dispute. In this case, what should have happened was that Congress should have had not only the last word, but the definitive word. I'm happy to answer your questions. I respectfully ask that my prepared testimony be made part of the permanent record of this hearing.
Thank you, Mr. Gerson. All of your prepared testimonies will be part of the permanent record, and we appreciate your testimony. We'll now proceed under the 5-minute rule for questions, and I will begin recognizing myself. Ms. Goitein, you said you gave us 2 of the ways you thought we should change the law. The first one had to do with clarifying that it was a significant change. And the second one was the idea that it ended after a certain number of days, 10 or 30 or whatever. Can you tell us, you had some others in your testimony. Can you go over those quickly? And then I'd like to ask Mr. Turley and Mr. Gerson to comment on your proposals.
Thank you for the question. My third recommendation was that Congress could renew states of emergency on a periodic basis up to 5 years. After 5 years, it can no longer be called an emergency. It has become a new normal of sorts. And at that point, Congress should be passing permanent laws or laws potentially with sunsets in order to address the phenomenon, rather than to pretend that it is still an unforeseen circumstance that's going on. The fourth recommendation I made is right now, under the National Emergencies Act, when the president declares an emergency, he has access to any of the statutes that are available during a national emergency, even if they are facially irrelevant to the nature of the emergency. There is no requirement in the act that there be some kind of connection. Now, a few of those laws, like 10 U.S.C. 2808, have some additional language that cabins how they can be used. Most of them do not, and there's no reason for that, and it invites abuse. So the law should clarify that emergency powers can only be used to address, for the purpose of addressing that emergency and not for any other emergency. Fifth, the law should make clear that emergency power can never be used as an end run around Congress. So if the current Congress has had an opportunity to consider and vote on the circumstances that lead to the emergency declaration, then the president cannot introduce a national emergency to get around what Congress, the current Congress, has decided. Finally, there should be greater transparency in terms of how presidents are using emergency powers. Right now, the president has to report every 6 months on expenditures related to the emergency. These reports have been filed since 2003. They've gone missing. I think Congress is getting them, but they're not publicly available. There should be a requirement, first of all, that the reports be made public, and second, that the reports cover not just expenses, but the details of what activities and what programs have been put in place with classified annexes where necessary. So those are my recommendations.
Thank you. And first, let me ask you this. On your first recommendation, it was that there's significant, that only if there exists significant change in factual circumstances that pose an imminent threat to the police powers or pressing national interest. The president could say that there is this factual change on the border, and if he did such, how does that first recommendation, how would that interface with our current circumstance?
In the current circumstance, I believe the only change that he has pointed to as a factual matter is that there are more families coming to the border seeking asylum. And of course, these individuals are coming to make claims they are entitled to make under the law, and they are seeking lawful entry into the United States. So that is not contributing to the problem of unlawful migration, which he cited as the emergency in the declaration. He hasn't cited any change in circumstances, any unforeseen developments, which is what an emergency is, other than that one.
Well, and maybe you're right, and I'm missing it in his official declaration, but in his verbiage, he's talked about drugs pouring in, and he's talked about the women being bound and taped, and you name it. And that's something new, I think. It's so new that it doesn't exist. But
it's new that he's talking about it. I think what we have to understand is that a problem is not the same thing as an emergency. Even a very serious problem is not the same thing as an emergency. Emergency has a meaning. It's not that obscure a word, and it does relate to unforeseen, sudden changes in circumstances that require an immediate response. Most of the things the president has talked about, drugs, unlawful border crossings, crime, are things that if you look at the government's own statistics, they're not getting worse. If anything, they are getting better.
Thank you. Professor Turley, what are your thoughts about her 5 recommendations, and do you have any others that are addition to that?
Well, I think I haven't really looked very closely at the recommendations by my fellow witness, but I would put up a cautionary flag that you should not try to write with such specificity that you turn this into an endless form of litigation and debate over the meaning of what's a problem, what's an emergency. You can define emergencies, but I think the key failure of the NEA is that this body doesn't have to take an affirmative act to allow an emergency declaration to continue. As I say in my testimony, originally the bill had that in it. Originally the Congress did the right thing and said that after a certain period, we have to affirmatively agree that there's an emergency and for it to continue. So without that agreement, it is a dead letter. That was removed at the insistence of the Ford administration. That could solve a lot of these problems. You wouldn't have to get into all of the weeds as to, what type of conditions are going to trigger what type of provisions, as long as this body had to affirmatively agree that an emergency existed. Then you could hold a hearing and address many of the fine issues that my co-witnesses identified, and I agree entirely that those are relevant factors to consider.
Thank you. Mr. Gerson?
Well, I'm not sure that life can continue very well without this act altogether. Because one starts with the Constitution, but speaking to the act, and you're here to amend it. Remember that its purpose was to clear the deck of a bunch of emergencies that were a decade old and were littering the field. And remember also that your fundamental power that undergirds any of this is the power of the purse. And so what you ought to be doing, it seems to me, is by amending this statute clearly, and everybody agrees about this, that you need a clear, plain English definition of what constitutes an emergency. What you're saying is we're giving license to the executive to carry on this basis without our intervening to cut off that activity by taking action with relationship to finance, what your Article 1 powers are. So you need to think, you're thinking about process when you do this. And as I say, I start with the Constitution. First and foremost, I think a clear definition, some practicable time frame should be attached to that, and the rest should be up to considering how this actually will work in practice, how Congress can play a meaningful role, particularly the House, which has this ability to originate revenue bills and appropriations bills, and how that will work in practice. That shouldn't inhibit a president, for example, with respect to the exigencies of exercising the war powers or foreign affairs powers, assuming that there's an emergency. Avoid those kinds of problems. Avoid the kinds of problems that the Tonkin Gulf resolution created. I think with historical reference, with a look back, with some common sense, you can simplify this, make it clear, define what your role is, and take a much more activist role, given the limited but very profound power that the House of Representatives has.
Thank each of you, and we'll come back to this, I'm sure, but right now I recognize the ranking member, Mr. Johnson. 5 minutes.
Thank you, Mr. Chairman. Professor Turley, can you just describe for us how the Obama administration's use of non-appropriated funds for healthcare insurers differs from this current situation, the Trump administration using statutory authority here?
Well, there's a very significant difference. I was a bit alarmed when I saw some members talking about using the precedent we created in Burwell to challenge this declaration as a body. And in my testimony, I strongly discourage that. One of the reasons I took the Burwell case is I've been a long believer in legislative standing. I believe a lot of the problems that we have today is that there are some types of constitutional violations by presidents that can't be challenged in court. They're sort of blind spots, and legislative standing solves that problem. This body worked for decades to get a court to recognize legislative standing, and we prevailed on that. Quite frankly, I don't think this is a very promising litigation, and I would not put that precedent at risk. Now, the reason it's not the same situation is that what President Obama did was, as you described, they came to Congress to ask for funding for the insurance companies under 1402's program. And this body, for whatever reason, declined to do that. The administration then declared that this would be a sort of implied permanent appropriation, much like the appropriations that pay citizens their tax refunds. The Congress doesn't require the IRS to come to you every year and say, this is the amount of money we want to give citizens. You give a permanent appropriation. It's like an open credit card. That is something this body does not like to do unless it really seriously looks at whether it wants that type of year in, year out type of appropriation. What the administration said is that we'll pay this directly out of the Treasury. And that's what Judge Collier said was a no-go. She just said, look, this is unconstitutional. Congress never said that. And this would really destroy the power of the purse. That is not what President Trump is doing. You can disagree with his policy, but he's acting under a federal statute that gives him this authority, and he is using appropriated funds. Now, I actually think that the challenge on the source of the funds could potentially have a positive ruling for the challengers on some, I doubt if on all of the funds. That is a statutory issue that we can debate. I talk about a little bit about it in my testimony. But that is very different from what happened in Burwell. And so what I encourage this body to consider is, regardless of where you come out on this, there are ample lawsuits pending, and they are being well litigated, including some by friends of mine. Let that happen. The members can come in as amicus curiae, but protect the precedent that we were able to win in Burwell.
Thank you for that. One more question. To what extent does the Supreme Court consider presidential rhetoric when they're interpreting statutory authority? So, I mean, are they going to consider the legal provision that governs, or are they going to look at comments made in the press? You know, where you remember President Obama famously said, if you like your health care plan, you can keep it. But could people have sued to keep their plan even if they didn't have that right under the Obamacare statute itself?
I actually may create a course on presidential rhetoric after this administration and its use in constitutional interpretation. I have to say that I disagreed with the Ninth Circuit to the degree to which it utilized the president's tweets and campaign statements in reaching its decision on immigration. I thought the first immigration order was dreadful. It was poorly written, poorly defended. It was really a product that was shocking. But ultimately, the Supreme Court agreed with the administration on the underlying core issues. And that opinion recognized the president's inherent authority on the border. Usually courts are reluctant to go outside the record to read the motivation behind a declaration, or, for example, the motivation of this body in legislation. They tend to try to stick to what you say in your official documents, and they do the same with the president. So I understand that the president certainly stepped on his lines when he talked about the fact that he really didn't have to do this. But I do not believe that that's going to be determinative, and I'm not even entirely sure it's that relevant.
So tweets cannot alter an order or a statute. No, that's my words, not yours. Real quick, Ms. Alvarez, I just had a quick question, and I don't mean this disrespectfully. It's an honest question, but you described your property. You said in at some part of the property you use a wooden corral built by your great-grandfather. You've been there for a number of generations, and there's a soft bluff that separates the river and your property. And you said very conclusively that there's never been, in your words, no drugs, no gangs, no terrorists have ever come across that property. The question is, do you have video surveillance of that whole length of your property?
Not of the whole length of the property, but towards the part where my home is and my parents' home, yes.
Does someone monitor it like through the night, like 24/7? I mean, the question is, how do you know? How can you be certain that no one has ever crossed your property illegally?
Well, it does capture Border Patrol people going through my property, and it sends alerts, so therefore, if somebody else would be passing through there, I would get an alert. I haven't gotten any.
Thank you. No further. I'm out of time. Thank you. I yield back.
Thank you, Mr. Johnson. Now recognize the chairman of the full committee, Mr. Nadler.
Thank you, Professor Turley. I unfortunately agree with you that courts are very reluctant to question the president's honesty or any president's honesty or motivations and go behind his determinations. But I think that on this one, at least as to the use of military funds, he wants to move military funds to have the border guarded by building a wall with military funds. Presumably the wall is a military asset for military use. But the Posse Comitatus Act specifically says the military cannot be used to enforce domestic law. So how can you justify the use of military funds for a military purpose that is denied to be a military purpose by law?
No, that's an excellent question, and that will be an issue the court will have to deal with. I have to say that I'm skeptical.
Because?
Because the military has been used on the border in the past. Presidents have called the military to the border. It's a classic use of the military.
Have they been challenged in court?
Not that I recall, but I doubt a court's going to seriously debate whether a president has the authority to send the military to the border. Your point, Mr. Chairman, is a perfectly good one. To the extent that they're doing law enforcement duties, that does bring up posse comitatus. That is a legitimate
Immigration law is law enforcement duties.
But the
Drug smuggling is law. What would they be doing that wouldn't be law enforcement duties?
Well, because the border is also a national security border. It is a classic use of the military. They patrol the border. And I'm just saying how I believe a court is going to view this.
But they patrol the border presumably against foreign troops. Insofar as they're talking about drug smuggling or illegal immigration, that's domestic law enforcement.
Well, I would say the border protection is a mix. And the question is, do you expect a federal judge to say, you can't order troops to the border to deal with border security? The answer is...
No, but I expect the federal judge maybe to say you can't order troops to the border to deal with drug smuggling or illegal immigration. National security, if the Mexicans are going to invade, 1848 isn't that long ago. Yeah.
Yeah, I do. I do think that this body can correct this problem. It can create clarity on the use of this.
Mr. Gerson, would you comment?
That doesn't currently exist in the statute.
On which part of it?
On the use of military forces to enforce domestic law, or is that what is happening here?
I agree with you in the abstract, but in the real, I have to agree with you because that's a point that we make in our litigation, and I expect it to be accepted. I think what to me is the right answer to that comes from the fact that sure, the president can dispatch troops to the border for a reason that is consistent with presidential war powers. There needs to be an underlying fact. If it's just a question of interdicting immigrants, that doesn't relate to the enumerated power that the president has.
The express purpose of the wall, which is to interdict immigrants and prevent smuggling, would not be a military purpose within the meaning of the Posse Comitatus.
Well, again, I'm on the public record in our filing saying that, and I happen to agree with it, but I'm not free to say anything else either. You know, as to other issues, can this be vindicated? Of course it can. I'm not burdened by. I'm not commenting on anybody else's lawsuit, but I'm not burdened by the problems that congressional standing raises.
Okay, let me ask one other question. Well, I agree with you on congressional standing, and I'm glad of that. In fact, it gets to a different question, which is probably a little off topic, but I'll mention it here anyway. The Justice Department maintains, as a matter of law, that no president can be indicted, as a matter of law. Okay. Justice Department maintains a lot of positions that one might contest and think they're wrong. Normally, however, one contests it in court. If the Justice Department thinks it can indict you for something or other, it indicts you. You move to dismiss on the grounds that it's whatever the grounds are, and the court will decide. But if the Justice Department decides it cannot indict a president as a matter of law, then it won't do so. And how does a court ever decide, how do you ever get the court to decide whether the Justice Department is right or not? It seems to me there's a catch-22 there, but
well,
I digress.
I'm quite familiar with that provision. It was written with respect to the potential indictment, not of a president, but the vice president.
Right.
And it wasn't tested. it served.
My point is it cannot be tested.
I think you're probably right. I think that
problem?
there is a range of non-justiciable disputes that will never be tested. There are some that relate to war powers that will,
Okay,
that
let me
will-
ask one
that will
last-
never be tested.
Let me ask one last question, because that's a different topic. What would you think of a statute, and Ms. Goitine recommended a version of this, that said any presidential declaration of emergency automatically ends in 10 days or 30 days if Congress hasn't affirmatively acted to extend it or to ratify it?
Well, it's impracticable. And I think that my fundamental look at that is not so much philosophical. I mean, how quickly can you obtain meaningful action, and what happens? Put aside dealing with issues of border security that have gone on for years that you can debate forever and come up with conclusions. What if we were under attack of some kind, say a cyber attack that hit us on many fronts? That was
Well, the president could declare the emergency, could act on the emergency. Congress, within 10 days or 30 days, could decide to extend it or not. Congress can easily act in that time.
Again, I go back to something I said earlier. You can extend it forever, but when you get to what the fundamental congressional power is, it's the power of the purse. And so what you're going to do is something that relates to the power that you actually have. If you disapprove what the president is doing, you're going to take steps to cut off his ability to do it, or her ability to do it.
Either you act either you automatically cut off the declaration of emergency if Congress doesn't declare it in a certain period of time. To act on the power of the purse requires a 2/3 vote to overcome the president's veto of your prohibition on his use of money, and that's shifting the burden.
Yeah, I don't say that you're not going to have a practical and constitutional difficulty if you do what you're going to do. But I think let me just say this. I think that with clearer definitions as to what constitutes an emergency, you're going to be on much better grounds, not only judicially but politically.
Clearer definitions are certainly in order, but without a time limit within which Congress has to, which was originally the intent in 1976, but without restoration in some version of that, it seems to me to say that Congress, to stop the appropriation of money, needs a 2/3 vote is turning Article 1 on its head.
Well, what happens, it's not my job to ask you the questions, but yours to ask me, but I mean, as you war game this in committee, what is it that you think happens after the expiration of 10 days or 30 days?
Whatever
or 6 months,
authorities the president was granted in the by the emergency declaration cease.
And what if the president doesn't do what you want?
Well, that's always the question. Hopefully you get an injunction.
But again, I think the time limit issue is somewhat artificial. That it may be helpful to have a time limit. You ought to consider that. But what happens at the end of it? I think you need to think. I think you need to think that through.
Thank you very much. My time is very much expired.
Thank you, sir. And I wasn't going to call time on the chairman, but Mr. Johnson did mention there were flights coming, so thank you for mentioning time limits. Mr. Armstrong of North Dakota is recognized.
Thank you, Mr. Chairman. Professor Turley, and I'm just going to start with, I think this is a great conversation to have. This is an educative, we've educated this responsibility over the course of 30 years, and taking some power back on this side of the aisle, and oftentimes the only time you can do it is looking into the future instead of looking into the present, because the present becomes highly polarized, and we all know that very well. And if you didn't before this week in Congress, you sure do today. So I do appreciate all that. But my question is not based on how Congress can act to change the law, because I think we should. My question is, under the current law as it stands now, what risks do you see by those who are filing these lawsuits against the president? I mean, just kind of along the lines of, be careful what you wish for, you might get it.
Well, there is a chance of bad cases making bad law, and that's always a concern that you have when you look at a high-profile case. I don't see how these cases can prevail under the existing law. I don't see a good faith argument that President Trump lacks the authority that he used, because there's virtually no conditions on that authority. And I also don't see how a judge is going to run the table on every one of the sources of these funds. Some of them will likely go through, and that's more than enough for the next 2 years to start construction. I think the more productive use of our time is to focus on how we can have a workable solution to the NEA, which had some very noble purposes at the outset. And one of those is to go back to the original draft and the concept of having an affirmative act from Congress after some period of time.
And that's another question I just have. We talk about legislative intent. We talk about what happened in the, what was originally in the act and then taken out of the act. But before we can ever get to that, we have to deal with the statutory framework as it exists. So you only go to legislative intent if there is a discrepancy in the statute. And I would argue, I'm not nearly as an accomplished a lawyer as the gentleman sitting down there, or the witnesses sitting down there, but it's so vague in so many different ways and so broad-based that I don't know how you would find a discrepancy in it, particularly in order to ever go to those kind of questions.
No, you can't, and history actually works against the challenge. That most of the emergencies that have been declared are largely economic and diplomatic issues. And frankly, they're not that significant in terms of emergencies. Most people, frankly, in the United States had no idea that there's dozens of national emergencies ongoing. They didn't have any idea that we had an emergency over uncut diamonds from Africa, or Zambians who might be, passing transfers of wealth. The problem is that this is so easy that the past administrations have just used it to get an edge or to deal with a problem internationally on a unilateral basis. So when a judge looks at this, is she really going to say, well, even though we have never ruled that a president cannot exercise the authority in this way, even though we've had dozens of still ongoing emergencies, I'm going to use my judgment as to what constitutes an emergency on the border on the NEA, even though emergencies aren't defined. Now, you might find a judge like that, but at the end of the day, I don't think you're going to prevail. I mean, that's what judges are not supposed to do. They're not supposed to substitute their judgment for what's an emergency. And when people say, look, well, it's not an emergency because look how the numbers have declined. There's less than 400,000 people being captured or arrested along the border. Once again, a judge is going to say, look, it's not my job to say that 1.2 million is an emergency and 400,000 is a problem. Elections have consequences. This president ran on this being a national security concern. He won, and he declared this as a national emergency.
And in my effort to get everybody to their flights, I will yield the rest of my time.
Thank you, sir. Mr. Raskin from Maryland. Professor Raskin, you're recognized.
Thank you, Mr. Chairman, and thanks for all of your great testimony. Well, let me try out a theory on the witnesses here. I noticed that most of the cases have been brought first in the name of the Constitution and then as a statutory matter, which I think is the right way to do it. To me, the whole current situation is solved by the steel seizure case where President Truman came to Congress asking for authorization to be able to seize the steel mills, and Congress said no. Then the president went out and did it anyway, and then the Supreme Court ended up saying, no, it's a red light by Congress, you can't run the red. And that's exactly what's happened here. The president came to us asking for money for the border wall. In good faith, what have you, we had a disagreement. We didn't give it to him. Now, he very blatantly, clearly, explicitly wants to go around the back of Congress and say, I'm just going to go ahead and use this money anyway. So we say that it violates our power of appropriation, the power of the purse, and the steel seizure case is on point. Now, if they want to plead that they've got some statutory authority to do so, we very simply say, well, no president has ever been able to invoke one of these rare emergency provision statutes for the purpose of circumventing the will of Congress, the express will of Congress. And I don't see why that doesn't settle it, and I don't see why we would lack legislative standing without saying one way or another what Congress would do in that situation. But can you guys just illuminate a response to what I'm thinking, Mr. Gerson.
Well, I am not dealing with the problem of legislative standing in the litigation that I'm bringing. I represent El Paso County and some other groups that are not only directly but immediately injured and have to do things now, and so...
And you're actually facing something like use of eminent domain power.
That's right, and the planning that has to do with that. We'll deal with all those issues in time. I've been an opponent of congressional standing. I think that it is rare that it can be supported because I do believe in the political question doctrine. What distinguishes this case that we have, that a judge doesn't have to make his or her own determination as to what constitutes an emergency. This case can be decided on the ground, on just the grounds that you describe. Of course, obviously you've read our papers and endorse everything that we've said to the district court. But what a judge can, and I hope does say in this case, is that this so-called event lacks all the characteristics of an emergency. I can think of any number of things that...
But are you speaking in constitutional or statutory terms?
Well, I'm speaking in constitutional terms, that a judge doesn't have to exceed textualism, if you will.
But we don't have a constitutional definition of emergency.
But more importantly, you don't have a statutory one, and so...
Well, at least the word emergency appears in the statutes, but
yes, but it's undefined, and there can be emergencies, and there can be emergencies. So, But in this case, where Professor Turley and I disagree is with respect to what the ability of a court is to decide something that, to me, is of an objective nature. That is within the realm of permissible activity by the judiciary. We also can win this case on purely statutory grounds for reasons that Mr. Nadler pointed out and you'd advert to.
Yeah, I mean, I tend to agree with Mr. Turley that on the statutory grounds it's more ambiguous because it appears to be, you know, a delegation to the president. Of course, if the interpretation is completely deranged and off the wall, then maybe a court would...
Yeah, but there are two parts to the statutory grounds. I mean, I think that a court can say this is not an emergency because it lacks all the objective criteria that any emergency would need to have. But in addition, with respect to the use of funds, I'm very confident that we're going to prevail on that.
Well,
we're going to prevail in front of conservative judges.
Doesn't the canon of constitutional avoidance help you too, that you want to interpret the statute in a way that's consistent with the Constitution? And here, the Constitution completely militates for a reading which protects Congress's power over the purse, rather than giving the president license to mangle the legislative will.
Now we're leaving Justice Jackson concurring in Youngstown, Sheet and Tube, and moving to Justice Frankfurter and Ashwander. Certainly constitutional avoidance can be applied, and we can win this on a pure statutory ground. I think it's more likely to go back to Justice Jackson. This is, to me, one of those things that he describes in his third category of disputes, the justiciable category, because, as you pointed out, the president is directly disobeying what the Congress has legislated.
Okay, Mr. Turley.
I think that the staff, this is part of the fun they had for Stuart and I to share the same mic as he argues against legislative standing. It took everything I could not to push the button. I strongly disagree with Stuart about his objections to legislative standing, but we can put that aside. What I would encourage the committee to consider is that there's no need to use that. The concern I have is that there's been a long suspicion that judges go to standing when they don't want to deal with a tough question. And so if you use legislative standing on this issue, you risk a judge avoiding these difficult questions and just saying, you know what, I've come to a different conclusion, you don't have standing. And you don't have to take that risk because you've got people who are ably arguing this. But the one thing I have to disagree with, and I see this with great respect because you're my ideal of a law professor with Article I authority, something that
a minor particle of it, but yeah.
I would disagree with you. This is not Youngstown. In Youngstown, Hugo Black said there is no statute underlying the exercise of authority. There is a statute here. You gave them a statute. And Jackson's first category
Well, it's certainly not the most recent legislative pronouncement on the issue. We had a very specific answer as to the request for money for the wall. I mean,
Yeah.
the president was clear about that. We were clear about that. I mean, there's no ambiguity
No,
there.
but that's not the same thing. Just because you did not grant an appropriation is not the same as an authorization of authority, which you gave to the president. And this is the first category under Jackson. Jackson says that if there's an underlying statute, the presidential...
That's been overridden by a more recent statement by Congress? I don't think so.
I don't think statutes are overridden by statements of any kind. You simply decided how much money to give the president. That doesn't speak very loudly to some amendment of NEA.
All right. I'm going to have to yield back, but can I just ask you one very quick question? Would you agree that would you agree that Congress should use its power under the current statutory framework to say that there's no emergency and to override the president?
Yes, I love Congress standing up for its authority.
Okay. Thank you very much. I yield back, Mr. Chairman.
You're welcome, Mr. Raskin. Next, we'll recognize Mr. Goodlatte's successor, Mr. Klein.
Thank you, Mr. Chairman. I want to continue that line. So, Mr. Turley, in the absence of a positive act to prohibit, are we to infer, Congress not providing the money that the president requested, that there is a statutory prohibition, therefore, to any action to provide money for said wall?
Yeah, it doesn't work that way. It's like Woody Allen saying, I wish I had a positive thing to say, let me give you two negatives. It doesn't work that way. That is, you have a positive grant of authority under the NEA. Your decisions under appropriations are informed by various issues of how much money you want to give, under what circumstances, how you're going to tie the money in. A court is not going to use that as a constructive amendment of the National Emergencies Act. It's just not going to do that. And so what you have is what Jackson described as the first category, where a president's authority is virtually unassailable, a grant of authority by the Congress to the president that he is using. And you can disagree with the decision that he's making, but you gave him that authority, you have the ability to rescind the emergency, and a court is not going to do that for you.
And I want to drill down, well, I'll get to you in a minute, Ms. Gauthier. The authority that was granted by Congress in 1976, Congress had enacted over 470 statutes by 1973. And so what we're doing is we're allowing, under the statute, using appropriated funds for military, in support of military action. Wasn't the military asked by Immigration Customs Enforcement for assistance at the border?
Right. Part of the problem with going down on the military construction is precisely that. Agencies are given deference under the Chevron doctrine, but more importantly, unlike the first immigration order, this thing is likely to be armor-plated with agency findings. A court is hard-pressed to substitute its own judgment for those agency decisions, including the need for military forces. Where there is a posse comitatus issue, and I think that can be a real issue, we'll go to what exactly they're doing along the border. But if you, as I say in my testimony, I drill down on each of the sources that the president has cited for these funds. And there are very strong arguments under every one of them that he can, in fact, use these funds. This has been a long-standing problem. When President Obama launched the Libyan war, I represented both Republican and Democratic members opposing that war for the absence of a declaration and absence of an appropriation. President Obama funded that war out of loose change. I mean, this body gives so much money to the executive branch without many conditions that he was able to fund a war out of what was just sloshing around.
And isn't it true that it's not even an emergency authority is not even required to move money around within departments in various cases? Okay, so Ms. Gauthier, I want to move beyond the debate over what the President has done, and quite frankly, this hearing would have, if this hearing is designed to examine that, it would have been better if we had had it before Tuesday or whenever the vote was by the House. But looking forward, I think we have a great opportunity here to make Article 1 great again. And so I want to follow up on your suggestions. Publicly available reports. Can you expand a little bit about what's missing and what we need to be doing.
Well, it would be great to start out if you guys could find them and make them public, because the president is supposed to report to Congress every 6 months on expenditures associated with states of emergency. That happened up through, I believe it was 2003. At that point, President Bush delegated all of the emergencies other than 9/11 and the Cuba naval blockade at that point were issued under IEPA, the International Emergency Economic Powers Act. And President Bush delegated to the Treasury the authority to submit those reports. From that point on, you can't find them in the congressional record. They were no longer read into the congressional record. So they are not publicly available from 2003 on. We also haven't been able to find any of the reports on the 9/11 state of emergency. So that, if you can find those and make them public, that would be terrific. We are, of course, have filed a FOIA request for those. But what I would say is, going forward, that was another omission in the statute for accountability purposes, that the NEA did not require those reports to be made public in some form, and also was a little too minimalist in what it asked for in those reports. The expenditures give us some information, but not quite enough.
Well, I do agree that we need to more clearly define what an emergency is. I disagree with you that Congress unintentionally left that out of the 1976 NEA. I think the president is fully acting within his authority to define that emergency. He's stated it multiple times. He believes there to be an emergency at the border, and I concur with that given the humanitarian crisis that's ongoing and the lack of the ability of ICE to handle that threat and that emergency on its own. So, but putting that definition in the code is something I would agree with and would be happy to work with the chairman toward that end. And with that, I yield back. Thank you.
Thank you, sir. Good maiden speech. Ms. Scanlon, you're recognized.
Thank you very much. I think it's great that we seem to have agreement by all four of our witnesses today that Congress should assert its power to declare this national emergency null and void. So it's great we've got a starting point. I just want to look at a little bit of the underpinnings on the differences in opinion that folks have. Professor Turley, you've given your opinion that the absence of an explicit definition of emergency in the National Emergencies Act gives the president virtually unfettered authority to determine when we have an emergency, right?
That's correct.
Okay. So you've argued that if we accept your definition, that this president or a subsequent president could, for example, declare gun violence to be a national emergency, right?
I don't see a basis to deny that, because there's no definition.
Okay, and similarly, if we accept your definition that there's, or your argument that there's no definition, then a president could declare climate change to be a national emergency.
Yes, the only caveat I would note when the chairman referred to melting down guns, for example, is that just because the president has the authority to declare a national emergency, that does not suspend the United States Constitution. So acts like that could very well violate the Second Amendment, or a president could violate other amendments. So the Congress could not pass a statute that allows for the suspension of the Constitution unless it's a suspension of habeas corpus.
Okay, and that's kind of where the rub seems to be here, and that's the part that I'm interested in. At what point does the declaration of a national emergency start encroaching on explicit constitutional language or implicit constitutional language? So, I mean, as I was looking at your argument that the absence of a definition means there's unlimited authority, I did what a lawyer does, and I started looking at dictionaries, because in the rules of statutory construction, we look at the purpose of a statute, or then we look at the plain language, the plain meaning. So when I looked at Black's Law Dictionary and Webster's and everything, I found the definitions differed a little, but the clear commonality was words like sudden and unexpected and unforeseen. And having worked in the immigration law sector for many years and having visited the El Paso border with my colleague, Representative Escobar, recently, I can tell you that the situation at the border isn't sudden or unexpected or unforeseen. So with that, Ms. Goatine, you've pointed out that you spoke in your testimony about abuse of emergency powers. Can you speak to whether the situation at the border meets either the statutory intent or common definition of an emergency, and whether it may be pushing so far into the idea of undermining constitutionality?
Thank you for that question. I certainly agree with Professor Turley that the National Emergencies Act gives the president pretty much maximal discretion. However, as I said in my opening statement, even the broadest discretion can be unlawfully abused. And I see that as having two dimensions in this case. One is that I do think that courts and certainly Congress are entitled to look at the plain meaning of words. We don't have to pretend that President Trump could define emergency as its opposite. There are some basic parameters that must be adhered to. And that I think courts are allowed to consider, either take judicial notice of or look at a dictionary. So I don't think that the president could say that a potted plant is an emergency. It just wouldn't work. There's not that much discretion necessarily. But the second part of this is what both of you were talking about, which is Congress cannot give the president discretion to violate the Constitution. The president could not declare a national emergency because too many people of color are voting. The president could not declare a national emergency because newspapers are publishing editorials critical of him. And there is strong evidence in this case that the president declared a national emergency because Congress exercised the power of the purse. That's a constitutional prerogative of Congress that he is trying to undermine with this declaration. And Professor Turley's analysis treats Congress's repeated votes against funding the wall as if they were legally irrelevant. And I don't believe they are, and I think they could factor in a number of ways, but the one I mentioned just now is one.
Okay, if I can quickly move to Mr. Gerson. Can you comment on the constitutional problem created by the president's declaration of a national emergency following the considered bipartisan, bicameral vote by Congress to fund a variety of border security measures other than the wall proposed by the president?
Well, that's the constitutional crux of our argument. That's the point at which it begins. We wouldn't be able to fit into Justice Jackson's third criterion without disobedience of a congressional edict by the executive. So that's our starting point. Okay. If you're implying that you agree with me, I'm happy to know that.
Yes, I do. Thank you very much. I yield back.
Thank you. Republicans have exhausted their witnesses, and so we'll recognize Ms. Garcia from Houston.
Thank you, Mr. Chairman. And I just wanted to make a little comment here. We keep talking about campaigns and campaign slogans, and I think one of our colleagues mentioned make Article 1 great again. I think the better button might be, just like we had It's the Economy Stupid, it should probably be It's the Constitution Stupid. But maybe I'll put some money together and get some of those buttons done real quick. But, I am concerned about the balance of power. I am concerned about separation of powers because I do think that this is a constitutional issue. And I really do thank everyone for coming today, particularly you, Ms. Alvarez, because obviously you've traveled a long distance. You come from my home state. You're from La Rosita. I'm from Palito Blanco, which is between Alice and Kingsville. I, too, grew up on a farm. And I don't recall, although I'm not next to the border, I'm close enough that I can tell you that anytime we always got concerned, and we always knew when somebody crossed over our farm, because there would either be a fence that was unlocked or some footprints. There'd be some sign that somebody had traversed our property. And I know that you are concerned. So tell me, again, you've not seen or know of any rapists or murderers or drug dealers or human traffickers or any, people trying to do harm to anyone around your property or any of your neighbors' properties?
Not at all, ma'am.
And have you had a chance to visit with any other of the property owners joining you to see if they share in your concern about what this proposed wall might be doing to your farm and your livelihood?
Yes, ma'am. I will say I can speak for my community. Most of my community is made up of elders who are not very familiar with the issue, that have been actually threatened at one point or another to sign over documents and stuff, or else their properties will be taken away. Mind you, we people in Starr County, and I can speak for myself and for my area, we do not want this wall, and we do not see a crisis, especially rapists, gang members, or an invasion.
Right. And are you the only party in this lawsuit, or is there a number of other parties in the lawsuit that you mentioned? I'm not familiar with it.
There's a few other parties.
There is a few other parties. Well, in your opinion, because you're down there, I mean, do you see a crisis of something that's, as one of my colleagues has described, of grave concern, and a change or something that may be endangering to your area?
Not at all.
Not at all? Well, thank you again for coming. I know it's a long distance. And Mr. Gerson, I wanted to first tell you that I think El Paso County is in good hands. And I wondered if you had reviewed or had listened to the recommendations that Ms. Goitin put forth in her opening statement, and had any reaction to her recommendations, or do you have any other recommendations that we should consider?
Well, I suggested earlier that I'd start with the definition, but as to Ms. Goitin's views, I've read her testimony. I find it edifying. I mean, you've noticed that the range of disagreement here is very small.
Well,
in terms of what your legislative purpose is going to be. So I would recommend considering all of those things. None of what you ultimately have to do deals with the lawsuits or other things that are going to be determined elsewhere, but you will have a chance to write meaningful law. As I say, I'm someone who normally, in my own political life, supports conservative judges because they read the law, that they're textualists, that they don't make it up, that they're originalists in terms of constitutional interpretation. I carry that through to this, and much of my criticism has to lay at the feet of the Congress, which has abdicated responsibilities that it has. I know from long history of dealing with this body that oftentimes things are left contradictory or unstated so that the law itself gets passed, so that somehow 11th hour agreement is reached. That's a bad policy to follow. And whether you're talking about who's covered by the Civil Rights Act, which is constantly being litigated, or anything else. And so I think it's fair to say that there's pretty great agreement in this room, that there's been an erosion of congressional power. As I suggested earlier, too often the Congress acts like a parliament. That's not what it was set up to do. Indeed, it was set up to be something else because there was a parliament that allowed a king to act in an arbitrary way. We fought and won a revolution.
What do you think about this whole notion of time limits, whether it's a termination period or a comeback and get extended, or any of those other options that have been mentioned?
Well, I said to Mr. Nadler earlier on that the concept of that you ought to address the question of time limits, but recognize that it's inherently problematic, that you've got to play it out because time limits expire, and what do you do when they do expire and no definitive action has been taken? You've got to play that through when you decide what to do. And you're not doing it just for yourself, you're doing it for future Congresses, you're doing it for future administrations that might be of a different party than you are. So you have to think about the country and you have to think about policy. And as I say, you need to be wise.
Okay, well, thank you. I think my time is up, and I yield back.
Thank you, ma'am. Now recognize Judge Gohmert from Texas.
Hey, thank you. Appreciate the witnesses being here. I was reading earlier article quoting from Washington Post and so many of ABC, NBC, repeatedly calling what's going on the border a crisis, constantly using the word C, the crisis word. But then again, that was when President Obama was in office. And now that he's not in office, those same media are now saying, oh, there's no crisis. I know there are some that have said the numbers are down last year, but if you look at October, November, December, January, as we had testimony from that very table earlier this week, it used to be 80% adult males coming into the country looking for jobs from Mexico, and now it's a huge majority. There are family units, or alleged family units, bringing children because they know if they bring children, they're going to be allowed to stay here. From the nights, and I certainly appreciate testimony from anybody that lives there, but of all the nights I've spent all night on the border, I've seen a crisis. And the crisis doesn't stop when the Homeland Security takes over. As some of the Border Patrol have related to me, the drug cartels call us their logistics. And I said, like the commercial, right. The drug cartels get them illegally into the country, and then they often provide an address or a contact in the city where the drug cartels are going to allow them to work off the rest of the money they owe the cartels. And then Homeland Security would ship them to those locations. So it shouldn't have been any surprise, people, in the last week or so, there was a massive bust in one of our biggest cities, drug cartel meth lab. When you see a rape tree, you see multiple rape trees, signifying this is where we've raped women. I guess it's all on whose view, but I would think that the women felt like it was a crisis. But I have been very concerned about the power we have given up here in Congress. I was concerned about that during the Bush administration, the Obama administration, and I thought it was a terrible time to give up specifically legislating appropriations. Some call them earmarks. Earmarks, if they're self-serving, they're an abomination. But if it's legislature specifically saying this is where you spend the money, it's normally a good thing for a Congress to do, and we haven't been doing that for a long time. So when the National Emergency Act was passed, it did indeed give up tremendous amount of power that Congress, I don't think, should have given up. But I know you're aware, when we talk about maybe a time limit, looks like the Obama administration has 11 of their emergency declarations still going on. Professor Turley, whether I agree or disagree with you, I always appreciate your consistency and integrity. And you had the comment that first and foremost, a court is unlikely to do for Congress what Congress will not do for itself. And it reminded me of a comment my friend Justice Scalia said when I asked him about something, not specific, because they don't give advisory opinion. He said, look, if you guys in Congress are not willing to do your job, don't come running over to our court wanting us to do it for you. And I think that you put it more succinctly, but that would seem to be, even though we've given up all this power, Professor Turley, it looks like the courts have been pretty consistent in saying, yeah, you gave it up, but it's your job, not ours. Do you know of any cases of courts of appeal other than maybe a Ninth Circuit that have said otherwise?
No, in fact, in the testimony, I talk about a couple of cases that strongly militate in the opposite direction. One was actually a decision, I believe, by Justice Breyer when he was on the Court of Appeals, called Beacon, where he looked at this issue of the law expressly stating that the Congress has to get together every 6 months. And emergency was challenged by someone that said, look, you haven't gotten together and satisfied that part of the statute, so this emergency must be invalid. Now, just look at that for a second. This, in comparison to the rest of the Act, that provision is the model of clarity. It says 6 months you must get together and make a decision or deliberate on this emergency. Even that, the court said, is not going to be binding under the statute. So what you're going to ask a court to do is to go deeply into a policy judgment of what constitutes an emergency. And you're going to have to do that after the Supreme Court just ruled in favor of the administration on its immigration orders and said that there was not a likelihood of prevailing in that case because the president has such tremendous deference at the border. I don't consider that a winning hand. I don't consider that a hand of any kind to go to court with.
Thank you. And Mr. Chairman, I would just submit I'd be glad to work with anybody on your side to try to limit the National Emergency Act, but I do think it's our job. Thank you. I yield back.
Thank you, Judge. I think we appreciate your coming to the hearing. And the previous time we've been here, we've seen a lot of unanimity that this needs to be something that could happen, and so maybe we'll have a bipartisan result of this. Ms. Escobar is next, and we appreciate your constituent and your lawyer.
I do too. Thank you, Mr. Chairman, and many thanks to our panel. Mr. Gerson, thank you especially for representing the great county of El Paso. For context, let me tell all of you about my community. I'm from El Paso, Texas, the beautiful, vibrant, new Ellis Island, which is on the U.S.-Mexico border. With absolute sincerity, I invite all of you, every member of this Judiciary Committee, to come visit. Please allow me the opportunity to give you a tour of our border. I am a proud fronteriza, a woman of the border. My family has lived there for over 100 years, so I can speak with some authority on this issue. I can assure you we have never been safer or more secure. While we have a wall in El Paso, we were safe long before it was ever constructed. And the question is, why have we been so safe? Well, there's 3 factors that I can point to quickly. Community policing by local law enforcement, a significant federal law enforcement presence, and most importantly, I believe, the fact that immigrant communities are among the safest in the nation. Our immigrant community is made up of 1/4 immigrants, and we have multi-generational roots in the region. El Paso is not unique in this way. Most of our southern border communities are just like this. And Mr. Johnson, we do face a challenge. I agree with you on that. You are right. And you are right when you say that we should be introspective about these issues in order to find real solutions. So the drug issue, which is one of the reasons cited for the wall, is not a new issue. We know it is not a new issue. Our country has long had an insatiable appetite for illegal drugs. The other reason cited, and this seems to be the one most discussed by my colleagues, is the thousands of Central American asylum seekers arriving every day at our doorstep. This, too, is not new. We first saw this phenomenon in 2014. Central American unaccompanied minors and families have been running from crushing poverty, violence, and persecution for nearly 5 years now. What happens is that they come in what's called a surge. This is the 4th surge in 5 years. Mr. Gomer just mentioned that the 2014 surge was called a crisis by members of the media. Yes, it was the members of the media, not by those of us on the U.S.-Mexico border. In fact, I just had Jacqueline print out a piece that I wrote and published for the New York Times about this very surge in 2014 called Why the Border Crisis is a Myth. This was published on July 25th, 2014. Mr. Chairman, I ask unanimous consent to enter this into the record.
Without objection, so will be done.
The question we should be asking is why hasn't the Department of Homeland Security, which has received massive federal investment, been strategic or nimble enough to deal with each successive surge, especially when we are in year number 5? I am not afraid of these families arriving at my doorstep. I live in El Paso. What I'm afraid of is the willingness I've seen by some to ignore the responsibility we have as a co-equal branch of government. I'm afraid of the amount of money that this non-emergency will be stealing from military families who were promised badly needed daycares and schools. In my district, I'm afraid this non-emergency will steal or could steal up to $275 million from Fort Bliss, one of this country's most important assets. Money that's being taken from our troops to fund a political prop. This obsession with a wall, which will be funded at the expense of our military, is heartbreaking to me. The day before yesterday, one of my colleagues on the House floor said that we are a nation at war. We are not at war. Yet in my community, barricades with concertina wire are being put up at our ports of entry. Starting this week, the return to Mexico policy will be implemented. We are turning away asylum seekers at our ports. We are driving them to places that are more treacherous and dangerous. That is the crisis, and that is a man-made crisis. That one is easily solvable. If we truly want to get to the bottom of this surge, then we need to do the hard work necessary to work with the Northern Triangle to address the challenges, some of which we have created. I shared that with you, Mr. Johnson. We have had a hand in driving people out of their homes from Central America. We have an obligation to solve this in a compassionate, humanitarian way. But again, this is not new. This is not an emergency. I know my time is up. And if I had just a couple of more seconds, I would ask our landowner, Ms. Alvarez, everything that you'd had to endure as an American property owner at the hands of this government. You've obviously had to hire lawyers. You've had to fly to Washington, D.C. to defend your property. I am very curious about what this government is putting you through.
This government has created a loss of family members, a loss of friendships, a division amongst us in our communities because, you know, people agree and disagree, mind you, over an issue that I strongly disbelieve in. There is no crisis. These people, like you said, are in the ports of entry, trying to come in with every lawful right, because they do have a right to claim political asylum. But somewhere, someone has created hate towards these people. We are at a record low of entries right now, even though the numbers are so high because the media has put it out there. Yet why do we as a community have to pay for someone who wants to put up a barrier, a wall or so, that is not going to work and that has been proven not to work? I am here. I've been going through a lot, but I am here and I am here to fight this. And I agree with a lot of things. Things need to change. We need to change immigration reform. We need to change parts of what the Constitution is there so we do not create loopholes where people take advantage of them and we are in the situation that we are in.
Thank you.
Thank you, Ms. Escobar. Ms. Dean, you're recognized, and thank you for deferring.
Thank you. Thank you, Mr. Chair. Thank you for the opportunity that you are giving our committee to examine and address the gross overreach by the executive branch. The President has already identified $8.1 billion in congressionally appropriated funds that he plans to take in order to build his ineffective wall, which he promised Mexico would pay for. In my home state of Pennsylvania alone, we have identified more than $165 million in military projects that could be on the chopping block and at risk. It's an irony that the protection of our homeland security, which the president professes to, he's actually going to harm. He's harming our military. I also want to reiterate the findings of 58 former national security officials who condemned the president's emergency declaration and stated that any redirection of funds will, quote, undermine U.S. national security and foreign policy interests. Mr. Chairman, if it is all right with you, under unanimous consent, I would offer this report into the record.
Without objection, so done.
It is signed by such people from both sides of the aisle with decades of leadership experience in bipartisan different administrations, such as Madeleine Albright, James Clapper, Samantha Powers, Leanne Panetta, Susan Rice, just to name a few. And here are just a few of their important findings. And it will be entered into the record. Illegal border crossings are at nearly 40-year lows. There is no documented terrorist or national security emergency at the southern border. There is no emergency related to violent crime at the southern border. There is no human or drug trafficking emergency that can be addressed by a wall at the southern border. And I won't go on, but you know the other very substantive findings. But I will end on the final one. There is no basis for circumventing the appropriations process with a declaration of national emergency on the southern border. So I'd like to ask the question of Mr. Gerson. I'll pivot to you if I can. Specifically, the president cited 10 U.S.C. 2808 in his proclamation, which, quote, requires the use of armed forces, end quote, and allows for the taking of funds that, quote, have been appropriated for military construction. Can you please explain why these two requirements in 2808 do not apply to this proclamation? And also, if you could speculate, and importantly, substantively speculate on the impact that these takings will have on readiness and morale.
Well, I'm an erstwhile Pennsylvanian and a military veteran, so perhaps I have some useful knowledge there, but that's not why I'm here. I'll address it if you'd like. The issue that we face, that you just described, is something I talked about earlier, and you're, in essence, paraphrasing something that I and Professor Tribe and the lawyers at Wilkie Farr who've helped us have said in our briefs. It's one of the reasons why, as I said to Mr. Raskin earlier, if there is a constitutional avoidance issue here, that we can win on statutory grounds. Funds that are appropriated for a specific purpose, pursuant to law as to what they are, should not be held to be flexible. But again, the point is that this whole thing can be defeated irrespective of any discussion of that, because there ain't no emergency. You know, this is the reverse of things. You know, if it doesn't look like a duck, if it doesn't walk like a duck, if it doesn't quack, it might be a hippopotamus, but it isn't a duck. And it's your job to define this law. I mean, I'm very appreciative of the remarks that are made by the people who live on the border. My son's godfather, his name is Susana Ortiz. He described himself as a wetback who made good under the name of George Ortiz as he moved from Texas to California. I'm conscious of these issues, but as I said, I'd be here making the argument that I made even if I agreed fully with the president as to the need for the wall. There's nothing illegal about your appropriating money to do that. The problem here arises because you specifically declined to give him what he asked for. It's no implication. You didn't do it. As I say, I think, as I said at the outset, that I am making a fundamentally conservative point. Plenty of conservatives agree with me, as you know from my descriptions in the documents here, that I'm affiliated with people well on to the right of center and way to the right of you, and that's okay. What you've heard here, and the thing that I hope to take away from this, and I hope that all of you take away from this, is the high level of agreement as to how you ought to be exercising the autonomy that some good conservatives like James Madison have bequeathed to you.
Mr. Chairman, if you would allow me, I know my time has expired, but just a couple of seconds to compliment Mr. Gerson, a fellow Pennsylvanian. I used to teach writing at LaSalle University in Philadelphia for 10 years, so I so appreciate your plain English when you say there ain't no emergency. Thank you, Mr. Gerson.
Thank you. We have, and with the unanimous consent, will enter into the record the following materials: a cover letter and 3 articles by Professor Ilya Soman, a statement by the Constitution Project at the Project on Government Oversight opposing Trump's declaration of a national emergency, a letter from former GOP lawmakers also opposing the emergency declaration, an article by Elizabeth Goitein, I think, in The Atlantic, which was the article that spurred my interest in this and kind of set the ball rolling, and an article by David French in the National Review. Without objection, so entered. I want to thank the members of the panel, our witnesses. Y'all were a great panel. I think in this is my 13th year in Congress, I haven't had a better panel that discussed the issues and probably brought the two sides together. I think we hopefully will have some legislation as a result of this hearing, and so I think it was very productive and very worthwhile. Ms. Alvarez, you are most appreciated for coming here. Very few people have been amongst such legal talent, and you have been a star here as a citizen telling us about the situation on the border, and I thank you for that. So I thank our witnesses. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses and additional materials for the record. And I also want to thank C-SPAN, because this was better than Michael Cohen. This hearing is adjourned.
Jonathan, it was good to see you.
It was.
It actually was.
Yeah. So we'll try to get the staff to work with your staff, and I'll try to come up with something. Good. Good. I think we can do something.
James is like, I don't ask